Your clients were specifically advised, they sought legal advice, they were advised to come to court as early as May.
Yes.
Now, all we hear is they did not do it.
Yes.
And there's no explanation.
Well, no,
what you say is they took steps, they sought legal advice. But legal advice says you've got to go and explain the position to court.
What one sees is that an attempt, firstly, to get to the bottom of the problem, and secondly, to report a plan to solve the problem at the same time. And that plan ultimately came together in early February when a technical task team appointed by the DGs that I've referred to.
We're talking about February this year.
Yes.
The advice I'm talking about is that the advice of Kasim in May 2016.
Yes, Justice Modelo.
And that's repeated in the advice of Trengrove later in October. And the advice was very specific. In paragraph 11, says Kasim, court will have to be informed of the change in status pertaining to project deliverables.
Yes,
now,
undoubtedly. I can't quibble with that. That was the advice received.
And that was the advice ignored.
I would respectfully submit it wasn't ignored. The client engaged with it, but there was a debate ultimately as to what the report should say. We're not going to make it. Yes, that was clear. But what is our plan? And the focus shift to what was the plan. 6 options were ultimately put on the table, technically at the highest level from the SARB, etc. And the minister and the head of SASSA chose option 1 in early February, and they immediately actioned it by requesting the Treasury's approval. The Treasury immediately rejected it.
I'm sorry, you're not helping us. You go to a lawyer precisely because you want to do the right thing. Now the lawyer tells you in May the right thing to do is to approach the court as soon as possible.
Yes.
We need an explanation as to why did you not immediately act on that advice, seeing that the information on the basis of which you concluded that you won't be able to do what you thought you'd be able to do is available. You take that information and say, on the strength of this information, court, we are saying we won't be able to do what we thought we would be able to do. Why was that not done earlier? That's what my brother wants to know.
And the answer is, I don't know. The submission I've made is that it seems that the client was trying to determine not just what the shortfall was, but what the solution was. But I do accept, and my clients accept, that it ought to have been done earlier. There's no dispute about that from my client's side. We accept that it ought to have been done earlier. Mea culpa, as far as that is concerned.
Fortunately, it can't be that easy. When you bear a responsibility so enormous, you especially in circumstances where there is a finding by a court that you've done something unlawful in the past, you don't want to be mistaken for disregarding the law again. So on the strength of the legal advice you have, you immediately rush to court and say, this is the position, bear with us, we won't be able to do what we thought we would be able to do. Or having failed to do so, at least there must be some explanation that would make sense to any objective person who listens to it.
I cannot take this matter any further. My clients accept they should have reported to the court sooner. My submission is, as their counsel, they ought to have reported to the court sooner than they did, far sooner than they did.